Good evening. At this time, I'll call to order our regular meeting of the Granby Zoning Board of Appeals on this day, February 12th, 2020. At this time, I would ask all board members to please identify yourself, starting at this end, please.
Ron Harrop, member.
Rick Bollier, member.
Jeremy Carrier, Chairman.
Kathleen Bronner, Vice Chair.
Anthony Huertas, member.
Okay, thank you. At this time, I'm going to introduce into record what we're here for this evening. We're going to be moving forward into a hearing. This hearing is a continuation that was originally scheduled from Monday, January 27th, 2020 to Wednesday, February 12th, 2020 at 6:30 p.m. here at 10B West State Street, the Senior Center, Granby, Mass. 01033, to consider the petition of the appellate, the Granby Bow and Gun Club Incorporated, seeking to appeal a cease and desist order of the Granby Public Building Inspector concerning violations of Granby zoning bylaws 6.29, special permitting ordinances concerning substantial expansion of a 500-yard range at 85 Chicopee Street, Granby, Mass., known as map 15 parcels C3, 4, 5, 6, 7, 9, 10, 11, and 12, as alleged and described in a letter dated November 25th, 2019, from the building inspector to the appellant. At this time, I just want to set forth all the ground rules for this hearing that you are present at this evening. All comments or questions made by anybody must be addressed and directed directly to the chair of the ZBA, which is myself. The Granby Bow and Gun Club, the party appealing, will proceed first, and the council will make an opening statement if it wishes to, and then they may call witnesses and introduce documents or exhibits as they see fit. When the club completes its presentation, the chair will call upon Mr. Briggs to do an opening statement if he so wishes, and any evidence and exhibits, also any witnesses at that time. When Mr. Briggs has completed his presentation, the chair will permit both sides, if they wish, to present a summary in support of their positionings. Please note during the presentation of both sides that the cases are being presented today to the ZBA. We will not entertain or permit questions at that time from any of those in the general public attending this meeting, which at this point would become a hearing. Okay? Unless counsel for either side calls them forward as a witness, they will not be allowed to speak. Anyone that disturbs the proceedings will be asked to be quiet or refrain themselves from discussion once. On a second time, they will be asked to leave the proceedings. If at any time we have to cease the proceedings because of an outbreak or any type of outrage, we will then cease the meeting until a police officer can escort that person off the premises.
Point of order.
Sir, I'm not taking any questions at this time.
Point of order.
I'm not taking any questions from the general public at this time. Please follow procedures or you will be asked to leave.
I am following procedures.
Sir, this is your last warning. Thank you. At this time, I am reading off the letter from Mr. Briggs. That was to the Granby Bow and Gun Club, Andre Mercier, President, dated November 25th, 2019, regarding violations of the Granby bylaws special permitting ordinances. This is what the Granby Bow and Gun Club is here to appeal. This letter is about violations to Granby's special permitting process, specifically 6.29, regarding substantial changes and expansion of use requiring a special permit. On Friday, 10/18/2019, Granby Police responded to a call about shooting at the Granby Bow and Gun Club, the club. They found no police service was necessary. As zoning officer, I went to the club the following Monday to follow up. I spoke to 2 members at the clubhouse who gave me permission to access the upper range. It has been over a year since I have been at the range at the shooting shed, which was closed to use by flagging. I saw a new narrow clearing that I had not seen on previous visits. It is separate from the broad general range, part of which I currently, with the shed, under a cease and desist order. It is about 20 yards wide with markers at set intervals. I estimated it to be about 500 yards long. In reviewing the site on Google Earth, it is clearly visible in the 2018 picture, but nowhere to be seen up and including 2017 pictures. The orientation of the clearing to the shooting area led me to conclude there is a relationship between the two. In researching the short history of the new extended range, I find many entries on social media provided to me from June 2018 identifying the range markers that I could see at the site, along with photos of people using the range. I'm drawn to the conclusion that its purpose is as a new shooting range. As such, I find it is a violation of section 6.29 of the Granby zoning bylaws, since it is a substantial expansion of use and no special permit allowing its creation and use has been sought or issued. The Granby Bow and Gun Club can hardly claim to be unaware of the permitting process regarding expansion and substantial alteration of use. The club is currently under a partial cease and desist for the creation of the 1,000-yard range. This new 500-yard range was created after that cease and desist went into effect. Given the obvious disregard by the club management for following the permitting process, I order you to cease and desist use of this new gun range. The cease and desist will remain in effect until relief is found and a special permitting allowing its use. If you are aggrieved by this decision, you have the right to appeal it to the Granby Zoning Board of Appeals. You are given 30 days from the date of this letter was issued to respond. Should you fail to respond in this time frame, you will be issued a non-criminal complaint pursuant to provisions of the Mass General Laws, Chapter 40, Section 21D. The fine per Granby zoning bylaws section 6.8 shall be $100 each day of non-compliance. Moving forward shall constitute a separate offense subject to the same fine. Signed, Gregory Briggs, zoning officer. At this time, I asked if the appellant has lawyer representation that would like to speak. And if so, if they would please come forward and present their case to us. Please state your name.
Good evening, Board.
Could you come up here for it so that way, yeah, we can, thank you.
Justin Rapelson on behalf of Granby Bow and Gun Club. We would waive our opening, however, we would like to address on the record an issue that's, that we've come across through some research. Come to our attention that one of the board members may have an ownership interest in some property adjacent to the club, and also at one point was vice president of the club. There is no formal written letter stating same, which could be a violation of section 19 and 23 of the conflict of interest law, so we just want to put that on the record.
Okay, do you have, how do you come up with this knowledge or who it is?
Mr. Huertas?
So you were an official member of?
Was.
Okay. And the treasurer.
Of the present club?
Not the present,
Or
there's
Granby
years.
Bone Club, or?
Yeah.
Okay.
And certainly the board can do whatever it chooses here, but we would like to put that on the record.
Okay, thank you for that. Bring it forward.
And like I said, we would waive opening and we go straight into.
But this time, I'd just like to hold you for one moment. Do any other members have any other thing they would like to divulge to the general public?
I don't know Mr. Rafelson here, but I know his grandfather worked with him many years ago. We're district court, Northampton District Court, and even out in Worcester.
Okay. Do you, anyone else with anything to
No.
disclose?
conflict.
No? Okay, you may proceed, Mr. Rapelson.
Mr. Marshall Johnson? Want to pull a chair?
I'm gonna turn this over to them. Okay.
Going back to the potential conflict, certainly it's up to the board, but we would ask that Mr. Huertas potentially consider recusing himself from the vote. That's up to the board.
I think it'll be up to Mr. Huertas, and I'll discuss it with him when we have an appropriate time.
Thank you. May I proceed, Mr. Chairman?
You may, thank you.
Mr. Johnson, can you please state your name for the record?
Marshall Johnson, I'm Vice President at Granby Bowman Gun Club.
And Marshall, what is your familiarity with the range?
The range has always been in that area.
Well, if I may direct you further, how did you become familiar with the range?
I don't know,
Do you do work on the range?
yeah.
And how often are you there?
A couple times a month.
So you're one of the more familiar people in the club. You can speak to the.
Yes, I am.
And
I'm
the
heavily
day-to-day
involved with
operations.
the day-to-day.
And this particular area that's referenced in the building inspectors.
I'm sorry, I'll hold you up for one moment. I neglected at this point, I would actually like each of the person that are making a statement to be sworn in. Please hold on one moment. I would ask you at this time to please raise your right hand as the person that is being sworn in. Do you swear that this testimony you are about to give will be the truth, the whole truth, and nothing but the truth? So I hope you got it.
Yes.
Thank you, you may proceed.
And Mr. Johnson, regarding this particular area that's in dispute, has this been a section of the range that's always been utilized?
You know, I've been a member of the club since like 2016, and from what I've gathered from the affidavits that we've collected, that yes, that whole area has been used for over the years, different placement.
And there was some reference in the letter to some possible maintenance of the area. Did you get permission from relevant town and federal and state authorities to conduct some
Yes.
maintenance on that area? What kind of maintenance did you do?
We cleared some brush and some trees and basic foliage kind of stuff.
And what authority gave you the permission to do that?
We had a notice of intent through Conservation Commission.
And when you say you had a notice of intent, do you know what time frame that was granted?
No, I don't remember. We'd have to.
Within how many years do you think?
Year and a half-ish.
Year and a half from today?
Again, I don't remember the exact date.
Now, in that particular area, since you've been there, members of the club have used it for shooting purposes.
Correct.
And nothing has changed in your eyes in the last several years as to that use.
No.
And are you, is it your representation to the board that there's been no significant or substantial extension or change to this property since you've been there?
No.
And based on your familiarity with some of the members who have been in the club since pre-zoning, and your familiarity with their testimony in these affidavits,
Yeah.
it's your interpretation that there's been no
Correct.
substantial change or extension. At this time, we would offer the affidavits into evidence, which should be part of.
There's two.
There's two each. These have been introduced at one point prior, and I do note that they are copies
Two each. Two and two.
And the originals, I believe, are in the town's records.
Would it be in a previous file?
Everybody's got another copy?
From 2017 or from last year?
2017.
Please pass this all the way down to attorney.
Yeah.
Have the affidavits been reaffirmed since 2017?
Oh, they were resubmitted during the special permit hearing.
Okay.
So this is the
Right.
third time they've been submitted to the board. Oh yeah, because there's some signatures from 2019. So, March 2019 is one of the signatures. It's within the last year.
Say March 20th?
2019.
Oh, okay. March 7th.
Just a second.
I don't think we need to go too much into detail. The affidavits speak for themselves. And they have been submitted to the town on numerous occasions. And I think some of you may be familiar with them. But whenever you'd like me to proceed with the witness.
Maybe in the interest of time, Mr. Rafelson, could you tell us where in these affidavits it pertains to this particular area that we're
The
speaking of?
shooting
Well,
area.
the area referenced in the building inspector's letter is the same general area as the 2017 cease and desist. We're talking about the same exact area. There's no fundamental difference between what's alleged to be 500-yard range and what's alleged to be 1,000-yard range. They're all part of the same range. So this is specifically referring to that same area. There's no real distinction. And I would maintain that everything in those affidavits is completely pertinent to this hearing as well, due to the similarity between the area that was cited in 2017 and the area cited last month, a few months ago.
Do any board members have any questions on that statement that was just made in the submittal of these?
No questions at this time.
No questions this time?
For me, I really.
I got one. Is the range 500 yards or is it 1,000? 1,000 feet or? Is that what you said? I didn't, they said 1,000 yards or.
The allegation in 2017 was there's a brand new 1,000-yard
Right.
range, which is subject of litigation right now.
Got it, okay.
And this new allegation is there's a 500-yard range that's brand new. And again, we maintain that this is all part of the same existing footprint that's always been there since pre-zoning, hence grandfather.
Okay, may I proceed?
Thank you. Mr. Johnson, could you just explain, based on representations that have been made, what your interpretation is of the footprint of the range?
I would say, that, everything on the other side of the firing line is downrange. I mean, the area is the area. I don't know how to explain it really.
Would you say that over the years you've set targets at varying distances?
Yes,
And you've always used this particular area of the range and you've always been able to shoot throughout the entire range?
yes,
And firing positions and backstops have needed to be maintained over the years?
correct.
And why is that?
Some of the backstops are natural. Some of the backstops are, have been built up by us and are maintained to keep a good pipe.
And this is particularly as a safety measure.
Yes.
And the leadership that's recently taken over the club has undertaken most of these renovations, correct?
Yeah, a lot of stuff has lapsed over the years.
So the assertions by the building inspector rely on this notion that the newer leadership has been changing around things to sort of beautify the range and to make it safer for people.
Correct.
And this was largely done in part due to financing constraints in
True.
the past.
Yep.
And recently you had more finances to work with, once you maintain the range in such a way that
Makes people wanna come.
Exactly. And maintenance over a large area requires hard work and planning.
A lot of it.
And how much, you personally, how much work did you put into this range since you started?
Hundreds of hours.
And that's a natural part of growing a range.
Yeah, I mean, during the summer months, you can go out and run a weed whacker for an afternoon and barely make a dent.
And that's what you would do in this disputed area, is things like that, weed whack, and aside from getting permission from other organizations, you've undergone your own personal maintenance projects.
Yes.
And would you say that this was a substantial extension of the?
Mr. Rafelson, if you're gonna ask questions, I understand we're not in court here, but if you have a question that you wanna ask the witness, let's not be as leading, please.
Sure. Now, have you always maintained the vegetation in this disputed area as well?
Yeah, we've been moving around in different areas of the property, trying to clean up a spot at a time.
So why would the building inspector state that this is different from 2017?
I don't know.
I actually have a question for you this time. So just looking at Google Earth things, because I myself have been able to, if we do spotty cleaning of a property, as you say, and I understand time constraints, because I've done ground maintenance for at least 25 years, how is it that on a Google Earth you would see a large clearing at one time versus spotty? Since you're doing the work there and
Well,
you're
it's
there all the
one
time.
spot for now, and then you can move to another spot, and you move to another spot.
But that's what I'm saying, large, vast areas. How would you maintain that you're able to have a large area and it's visible from space, but your part of your thing is that you're spreading all around because of time restraints or trying to do it? So like in your words, how
I
do you
don't
think?
understand your question. It's like,
My question is, again, it seems like some of the defense that you're trying to say right now is that things is, over a long period of time, you're doing work, and that's understood, and that you have to jump around, and that this is all part of one area, but yet we're able to see a vast clearing. I'm just wondering how that's possible for just a minor amount of clearing, 100 hours at a time, this or that we can see such a large, vast opening. That's not noticeable from one year, but is for the next. If it's always been there and always been part of a range.
I don't know, I wasn't there for the beginning of that project, or physically there. I was there part of the club, and I think they had a good turnout of help, you know.
Just so I know, before we go further, so what year did you start the process over there doing the work?
We started doing stuff, well, they started doing stuff before I became a member.
Well, no, I'd like to know when you became a member, because we're talking about your
I
work
think it
and
was
how
the
much
end
you've
of
done.
16, I'd have to check.
Thank you. That's all I have for you at this time. You may continue, Mr. Rafelson.
I have no further questions for Mr. Johnson.
Do any of the board members have any questions at this time?
No.
Thank you very much.
At this time, we rest with our witnesses.
Okay.
Good. Do you have any, you want to wait for a closing statement after we hear from Mr. Briggs? Okay, at this time I'd ask you to please be seated in the general audience. This time I'm going to ask Mr. Briggs to please come forward. Have a seat. And if you can please state your name and title for the audience, please.
Gregory Briggs, I'm the building inspector and the zoning officer.
Thank you. And at this time, I ask you to please raise your right hand. Do you swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated. So at this time, I'd like you to please present what you have that we are here for today in regards to your site visit that was for at the club.
Well, I went up to the site visit, as it says in the letter, because there was a call in, and I simply went to see, to make sure that nothing had been out of bounds as far as use of the range. I went up there, I think it was the first day of archery season, there were two guys getting suited up to go out. They said they had been there or they knew that the police had been there, that it really had amounted to nothing. I said, well, okay, do you mind if I go up there? So they said, well, come on up and check it out. I went up to the top of the hill, and like I said, it had been more than a year. I think it was the end of September of last year was the last time I was on the range again, to make sure that the club was in coordination with the cease and desist, which they were at that point. And I hadn't been back. And in looking around, it was evident that the shooter shed, which is under the cease and desist, had not been used. There wasn't any evidence of any use of other part of the raised mound, which is the only way you can really gain access to the 1,000-yard range. And that's when I saw a new clearing going in an entirely different direction into a wooded area. And I was, like I said in the letter, it's about 20 yards wide, and there were markers going out at increments. I estimated it to be 500 yards long at that point. There really are no substantial backdrops or buffers to prevent. The way there are on other parts of the range have mounds built up for protection. This didn't seem to have any of them. But its relationship to the shooting area itself, there's 3 permanent benches there that are outside of the shooter shed, made it pretty evident that it was used for something. And then, go on Google Earth, you can see that right through 2017, in this particular area of the club, it's heavily wooded. And then in 2018, all of a sudden, there's this long range going right down through, separate from the other broad area of the range. Further social media stuff shows that there were targets located before the area was cleared. Then the area is shown cleared on other social media events that were actually held there. There's several people shown shooting at this range as of, I think it's June 2018, whereas all the other previous dates that show shooting happening at their events never show this range being in use. And actually, I think in one of the later social media postings that happens after 2018, there's actually yardage indicators given for the various targets. I don't remember what they are, but they go out to approximately 500 yards.
Okay.
So at that point, in doing due diligence, it's new. It's new as far as I can determine in whatever evidence can compile itself. There's nothing posted about this particular range until after 2018. And it's separate. It's not part of the 1,000-yard range. If I'm standing at the shooting shed, the 1,000-yard range goes at approximately 1 o'clock, And I would say this goes more like tentacle. And it's entirely separate from the other targets that are placed out in the general range.
How many times did you say you visited the club over the last years that you've been involved with the town of Granby
I've
as a
been there either
inspector?
3 or 4 times.
Okay, so this wasn't just the second time popping on there, you've been at least 3 or 4 times. So you have eyewitness accounts of what it would have been.
What brought your attention to go up there?
Well, like I said,
Call
somebody
the
had
police.
complained to the police
Call
about
the
the
police.
shooting. And then, because there'd been so many complaints from the neighbors about the shooting, the police can't do anything about shooting. They went out there, the shooting within the regular allowed hours. And people are saying, well, why are they using the illegal range? Sounds like there's firing a machine gun up there. It's like, okay, well, there hasn't been any evidence that I've seen so far that they're doing anything but target shooting. But I'll go out there. I got permission to go up and look at the range. There wasn't anything out of sorts. There were no bullet casings from a 50 caliber machine gun. There were, there was plenty of empty casings around, but that's not unusual at a shooting range.
Right. Thank you.
Do any of the other board members have any questions?
I just wanted to just for clarity, you've been there 3 or 4 times, and from this visit to your previous visit, it's clear in your mind that this area was not cleared or in use compared to your last visit.
I can't say that it wasn't there in September of 2018. When I
Okay.
was there in 2018, I was there to make sure that the shooting event that was going on was in compliance with with the
Okay.
cease and desist. And it was.
Okay, yeah. But is it clear to you that this area that came to your attention, the new clearing, was not something that was there in the past? Just trying to make sure
When I
that,
was there at the end of September in 2018, all the firing that was going on in the broader range of
Okay.
the zone.
And not in
It was
this
not
area.
in this particular area.
okay.
Whether it was cleared or not, I can't testify at that
Okay.
point to whether it's clear or not.
Any other questions from any of the board members? Okay, at this time, I believe we're set with your testimony, and we, of course, hold the right to play back for more questioning if we deem it necessary.
So in doing my follow-up, I'm just going back to the findings of the 2017 decision.
Right.
And to me, it's clear that it's a substantial change of use or increase of use,
Mhm.
and thereby needs a special permit. And there wasn't one applied for.
Correct.
Yeah, right.
Very good. All right, thank you very much.
Maybe you can fire us like just one question from,
I may, yes, you go ahead.
just in your experience as a building inspector, what is your definition of a substantial expansion? How do you perceive it, especially in relation to the club?
In relationship to the club,
Yeah.
you can go back over, well, close to 10 years now, and see how the broader range has been opened up. I wouldn't even guesstimate how many acres were opened. And all that was through 2012, I think, was the permit to special, the shooting shed and the range. And then I wasn't in town during the first sessions of when this all started to come about, so this appeal from 2017 predates me. But at that point, in looking at the historical layout that's offered by Google Earth, this range just seems to grow. So then in 2017, you have a cease and desist that's issued, I think it's 2017. And this anything that I can see, this range, which is separate from your broader range, is not there. In 2018, it's there. So, I don't know if that answers your question specifically enough, but
Why does 500 constitute a substantial change in your eyes versus 300 or 200?
there is no marker for substantial change. There's some language that goes with it.
Mr. Rafelson, are you referring to the powers test, which is a legal definition?
Well, as a building inspector issuing a complaint, you should have familiarity.
Well, it's certainly a difference in quality or character. It wasn't there before. It's not like the club hadn't been made aware of the fact that we needed to apply for a special permit to engage or enlarge their use.
I think Mr. Rafelson, actually, I'm gonna interject there for a moment, just by even some of the things that I just received from your office this morning. Page 5, you think converting from a small gravel pit to a large gravel pit, 318 Mass 216. I guess that's in the interpretation of the law when they're going forward in a court. At this point, I would say you yourselves have said you're going from something small to something large. Every definition I hear from everybody at the club so far is the range. Everything past the firing line is the range. I think that's where we're having an issue, is that the well-defined cut areas that are downrange for actual shooting and for targets have changed drastically. That's obvious just by looking at Google Earth. As if you looked at a gravel pit with fine defined markings and they're doing excavations for 500 yards. Next thing you know, it's 700 yards, it's 800 yards. And a gravel pit yearly has to go back to actually get a permit. Just out there that, again, permitting is required for expansion, severe expansions.
And I guess if there's any question about the dating, I believe the club was just denied a cutting plan by the forestry folks because their determination was that the application they were looking for was to prevent future regrowth of woods. And that was on land that they were determining had just been cut.
Do we have anyone from the club that would like to come forward and swear testimony as to whether that is true or not true at this time?
Can you clarify as to whether what is true?
Whether it's true that they have applied for a permit to clear wood and was denied? Or are you denying that?
What was the habitat? That was the habitat program.
Said we didn't need a permit, because we weren't cutting enough.
It's not in front of the board today.
We're in litigation.
I find it to be pertinent if we're talking about the amount of land that you want to clear and we're talking about expansion of use being severe. It kind of goes back to my question of Google Earth when we're looking at the amount of land that we're spotty clearing or not, whether it's severe expansion or it's not a severe expansion. Substantial expansion. Use my correct wording.
Mr. Chair, if I can suggest, before we get a little too far off topic, stick to the reason why we're here for this alleged either creation, again, we can debate terms here of a new shooting range or substantial expansion of the existing range. I think perhaps we should stay within the lanes there as opposed to, unless, Mr. Chair, you believe that. I'm not aware, I don't believe, of this cutting program that somehow it factors into this particular area.
Well, I don't know where it was applied for either, so that's
Okay.
why I kind of want to try to figure out if there was and where that area was planned for. Is it off of that area or, separate completely from where the shooting area is? I don't know. You own a lot of acreage. It could be totally separate from the shooting area.
Mr. Chairman, as co-counsel, this matters in litigation. This appeal is exact same issues that are in litigation currently, and I assume when whatever happens here, it will end up being merged in litigation. And this is hundreds of acres that are a part of a shooting range. And how the club manages their vegetation and what amounts they manage at any particular time has no relevance to what the size of the range is, what the use of the property is. It couldn't prove one way or the other what the historic use of the property is. Whether you choose to manage vegetation all at once, or through some program, or through some permit, or through some other means, or through deforestation from airplanes with pesticides, there are many ways to manage vegetation, and we've instructed Mr. Johnson is not trying to be difficult. We've instructed him not to answer questions that go astray from the key facts that are at issue here, because we are in litigation.
Okay, I believe we're all set with you then at this time. Does the board have any discussion they'd like to make at this time amongst ourselves, or any other witnesses you want to see come forward? No.
I would just advise before, if you were gonna decide to close the hearing and then deliberate that, at that point,
Yeah.
there's no going back asking for,
Additional-
This time I would
Additional
make a recommendation to the board that we actually do not close the hearing and that we wait to come up with a decision.
and,
A discussion upon.
I would, I mean, certainly if we plan on going any further today, I would like to take a recess to talk to Mr. Huertas, to decide. At this point, if we were to go any further, I would have to have time to research this and, the involvement, certainly aware of the conflicts of interest law. If Mr. Huertas would not be able to participate, then all 4 members would have to be unanimous in order to overrule the building inspector, as opposed to 4 out of 5. But given the potential issue brought up by the appellant, I wouldn't feel comfortable in representing Ms. Huertas as a member of the board to go forward until I know more about it.
We do need to make our final argument too, whenever you let us.
Okay. Okay, so do you have any questions before we go to that final? Okay. All right, at this time, Mr. Rafelson, if you would please come forward again. Again, a reminder that we will not be taking any questions or comments from any of the general public. I thank you for your understanding at this time.
Thank you, board members. I have to just be short and sweet here. The building inspector testified that he noted that there was a new section of the range, and said section, in his opinion, was a substantial expansion pursuant to Massachusetts General Laws 40A, Chapter 40A, Section 6. This particular area of the range is a swath of land that's been continuously used since pre-zoning, and in fact, many of the firing positions are on the same so-called legal range, and many shooters use that range to shoot on all sorts of targets throughout that one general area. Now, if we're looking at what defines a substantial expansion under the case law, we can look at our memorandum of law. I don't have to go too much into that, but I would like to point out one case in particular, which is really the seminal work on non-conforming uses, which is Oakham Sand and Gravel Corp. Versus Town of Oakham. And the site on that is 54 Mass App CT 80, 2002. And in that case, you're looking at a sand and gravel removal business, which was on a 108-acre parcel of land, so similar to this particular case where there's several hundred acres of land. And it had been used since prior to zoning by various owners to remove sand and gravel. And in 1985, only about 1,500 cubic yards of material was removed on a seasonal basis, primarily from 4 acres. And then just 10 years later in 95, they used 50,000 to 100,000 cubic yards of sand and gravel, which from 1,500 to 50,000/100,000, that is absolutely substantial in a way that goes astray of case law and Massachusetts General Laws 48. And in addition, they changed their operation from seasonal to year-round and began using 25 acres of land in that removal operation. Now, the reason I point this case out is because this is a situation in this particular case where we're looking at very incremental changes that do not amount to that substantial threshold. Where in the Oakham case, we're looking at a volume of sand that's 30 times greater than in 1989, in 1985 or 1995. And in the particular case that we have before you today, we're talking about the same exact parcel of lands being used in the same manner, and we're speaking in terms of apples and oranges here. We're looking at changing of targets, movement of targets, firing lines being maintained, particular areas of vegetation being cut. We're not talking about 30 times greater. We're talking about small incremental changes. And that case law has been backed up many, many times over the years. And we look at other cases where to reach that threshold of substantial expansion, we're talking about changes that go from one use to another, grocery store to a caterer, or adding completely new buildings without a permit, or going from a small pier to a large marina. We're talking about expansions that go beyond this threshold of incremental change. So for those reasons, Board, I would ask that you think long and hard about whether this is indeed a substantial extension pursuant to Mass General Laws, Chapter 48, Section 6, and I would ask that you overturn the building inspector's determination. Thank you.
Thank you. How long of a recess or break would you think you would need, Mr. O'Toole?
Probably at least 15, 20 minutes.
Okay. At this time, I would like to go to a break so that we can have our council discuss this situation with a board member. So at this time, I ask all members, we'll have to vote on that, correct, to actually take a break or
Motion
take a
for
motion?
recess? No.
Brief recess, yeah. I think the chair can do that as well.
Okay.
Oh, okay. So we're taking a brief recess for approximately 15 to 20 minutes until council comes back with our board member. Thank you. Okay, at this time, we're continuing our hearing back from adjournment. At this time, I ask Mr. O'Toole, please discuss what we talked about.
I have had a opportunity to speak with Mr. Huertas. At this point, especially, I don't know how the board is going to proceed with the rest of the evening, if at all. I've advised him, in an abundance of caution, to abstain from voting or participating in this matter, certainly for tonight. And I believe he agrees with that. So he'll be recusing himself certainly for the rest of the day.
Okay, at this
Right.
time, may the record please show that Mr. Huertas will be abstaining from any of the voting and questions. He is, of course, allowed to stay with the board up here while we continue this process. At this time, I would just like to fully disclose that when we went into a recess, we were handed a couple pieces of paper with photos on it. And at this time, I'd like to recall Mr. Briggs up here, as Mr. Briggs was the person that had brought this forward to us. And at this time, I'll remind you that you have been sworn in, and we'll hold that still to this time. Okay, so can you please explain what you had brought forward at the time of recess for us to look at?
Well, the first one is a picture of the range as it exists in June of 2018. Another picture that predates it from May of 2018, which
Mr.
shows
Briggs, just are they marked at all so that,
the dates are on both of these.
okay. I'm gonna ask you that when you refer to, the first one that you referred to, if you could mark it with a 1, the second document you referred to with a 2, so we know exactly, when we go back and forth on these, if we do, we can do that.
Okay, so I'll mark them chronologically. The first one is dated May 8th, 2018. Number 2 is dated June 2018. Picture number 1 shows target markings in a wooded area. There is no range present. Picture 2 shows the range developed. Picture 3 is a photo of the range with letters on the targets.
All right, we were not presented with any of those, so once you are done numbering them, I will need to have copies made so we can present them to
Okay.
council, please.
And the letters on this picture correspond with the target pictures on here. Another picture I'll label 4, which shows the distinctive arrangement of this particular range to the broader range. And 5 and 6 are the cutting plan that was disapproved in October of 2019, which shows it in correlation to what appears to be the range itself.
Okay. Just one question, did you use those solely to make your decision after visiting the last time, or did you use your prior experience on the range, looking at it to make a decision of the new cuttings?
Well, it's been an ongoing, I mean, I can't attest to the fact that this range was there in September of 2018. I was looking at another part of the range. But it stood out when I went up in October of 2019. Then when I went back and started actually looking at what's available, it became clear that it is a range. There's nothing that predates 2018 with the use of this range on social media that I can find. And then in October of this year, the forester disapproved the plans because he said it was meant to be a permanent deforestation, so he wasn't gonna allow it on the area that is the range, whereas they're trying to generate forestry, as they said, in other places, or maintain forestry in other places. And at that point, it's like it just became clearer and clearer to me that it was specific, new, and as far as I could determine with what they say in chapter 40, that it was substantial and different.
Okay. Does the board have any questions that they would like to?
Who was the person who said they were gonna make it permanent? Was that the forestry person you were telling me about?
The forester said, or I think it's, he talked to me on the phone when I called him up to find out what he actually meant. There's a little paragraph at the bottom of the disapproval. And
Yeah,
he said,
I mean,
no, they wanted to make it so it wouldn't go back to holding trees, which makes sense on a shooting range.
Who's
Yeah,
they?
I mean, that would be a
Well, I'm
future
assuming
thing,
that's the
so.
club.
The club said that?
Yeah. That would be a future thing, so I'm looking more at what's already been done than
Right.
future tense. We can't hold them accountable for anything they wanted to do in the future, only what is evident now. Just so the board members can make that clear too. As the board members looked at, do you have any other questions? other
No,
than-
I just needed to know that.
And so I don't have access to a color printer right now. I could have that done tomorrow.
Would that be acceptable to you, or do you want, we can do it right now, it'd be in black and white, or you can view them obviously in color,
Maybe
so that way you can see.
see them for.
Oh, yes, definitely.
Sure.
Perhaps you can come up and, yeah.
Take your time looking at them. If you have any questions, you'll know what number to refer to.
Okay.
Please wait a moment, we're gonna look it over in case there's any questions from the council. Okay. Did you have any questions on these pictures to Mr. Briggs?
No, I just want to put on the record that the statements regarding the forest cutting are largely irrelevant and, in our opinion, inaccurate, but we don't want to say anything further in litigation. We don't think it's necessary to address, as you stated, as a future issue, doesn't have any pertinence to this matter.
Correct. Okay. Thank you. That's all you have at this time for Mr. Briggs? Okay. This time, Mr. Briggs, we thank you for your testimony. And
You want me to hold on to these and get color copies?
yes, please, so that way we can have them all put into the record.
Oh, hold on.
Yeah.
Are those the ones, are those the originals that have been marked?
These are
Yes.
the originals that have been marked.
We're gonna keep it in our file, and we're gonna
They can't break it.
get the copies of
Three
those.
more.
We'll give you back copies.
But
2,
you've got
3,
6
4,
copies
5,
there, and I
6.
got 3 there.
Yeah, the rest are there.
Attorney Rafelson, are you gonna want to have either Mr. Johnson or to indicate what they think, the club thinks shows on the photos, or no? Okay.
Just a moment, please. So make sure we have them all in order and in our file. Those are the extra copies. This time, do we have any more discussion of the board, any questions that we would like to ask from any of the witnesses or any of the council? Do we have any motions at this time? Do you want to close the hearing at this time for any of their, yes, Mr. O'Toole?
Usually when we approach this stage of a hearing, I would again remind the board members that once the hearing, the taking in of evidence is closed, that's gonna be it. So I'd ask that you think long and hard about that. Also, under an appeal of the zoning enforcement officer, the board has 100 days from the date of submission of the appeal. On this date, for this case, was December 18th. 100 days, using an online calendar, indicated that 100 days would be approximately March 26th. That doesn't include the 16-day gap that we've had between the 27th and January 27th and today, which would give us some additional time, but that the board should not feel compelled to make a decision tonight without having looked at all the evidence. If there were questions that were to be asked of myself regarding legal opinions that I would probably need to research, you know, as you deliberation would be in public. Anything that I would get back to you would also be public, in order to assist you in your decision. I think it's clear that regardless of what direction the board goes, and again, under 48 section 15, now that our 5-member board has been whittled down to 4 voting members, all 4 would have to be unanimous on their decision to overturn the building inspector's decision. But in light of everything, I would imagine regardless of where the board goes, it's already in litigation in the Boston Land Court on appeal, initiated by the gun club. I would imagine that whichever way the board goes, whether again it's not in favor of the gun club, I would imagine they would immediately appeal, file suit, merge, consolidate the cases, or if they are successful, an aggrieved party may also do the same, so highly likely. So I would suggest that, given the amount of information that we have here, documents that we have not seen before, it may be wise to take the matter under consideration, set a time for a date for the board to meet within the next couple of weeks. I wouldn't suggest getting close to that March 27th or 26th date, because you're still gonna have to have time to write up a decision as well and have it served. But that, I think it does deserve careful consideration. Again, it's only 10 of 8, we can be here as long as we need to, but I wouldn't want the board to feel that they need to make a hasty decision. The statute does give time, and I think anticipates thoughtful reflection.
Thank you.
Thank you. Can I answer council question? Or no?
What was your question
Well,
to the
no.
council?
Not hard,
Go back.
something.
Oh,
No, I
not
want,
our
I want to
council.
know, I want to know, is this their proposed findings that they want us to go on?
That was what they submitted this morning.
I would,
There's nothing,
but
them answer?
it's, what you have in front of you that was submitted by the club, by Attorney Rafelson today, was substantially similar to back in 2017, when we had another appeal hearing on a cease and desist. The board asked for essentially closing arguments of the parties. Attorney Rafelson submitted something somewhat similar. There were other issues that are not before the board today that were then, so it's somewhat modified. And also back in 2017, when the select board was the zoning enforcement officer, they enlisted separate outside counsel so that there wouldn't be a conflict with Attorney Ryan in our office at the time. So they had their own outside counsel, Bacon and Wilson, submit findings of their own, which is the 2017 document that's been referred to previously by Mr. Briggs. So is it proposed findings? I wouldn't say.
I wasn't here in
I'd say it's-
2017, so that's why
Neither was
I'm just
I.
questioning, yeah.
So I would say it is more of a memorandum of law in support of
What they
their
want.
position.
Okay. Thank you.
Does that answer your question, or is there something you still like
No,
to ask?
that answers my question, I just, yeah.
Any discussions on it, where you feel, or a board, where we should go from here for possibly allowing more time to ask Mr. O'Toole some legal questions to how to come up with a finding for this, or whether we'd like to look things over, our evidence more. Any discussion on feelings?
Well, some of the documents we've received tonight. I mean, if, I'm not sure that opinions would be changed, but I also believe in caution in looking at the materials. If we indeed have the 100 days, to make a decision, or within that time period. I'm open to that, I mean, I'm happy, I'm, not tied either way, but, I tend to side with, Attorney O'Toole to use caution and good thought in making a decision, in fairness. That's just my thoughts.
Okay. You feel
I
similar?
agree, because I wasn't around for the 17th, I'd like to read this a little more.
Yeah.
Sorry, guys.
No, that's what we're here for, is to make an informed decision, so.
If I may just, Attorney Rafelson, given the photographs that have been presented tonight, is there anything that you would want to present to rebut so that we don't necessarily close the hearing, that you would like to submit?
We certainly reserve the right to. But
Well, I think what happens is if we close the hearing, then
That's
then that's it. So I guess what we can do, continue the hearing, okay, I think what the board has to do, and since we're all here, if you are gonna submit something, I think we're gonna have to have it by the next hearing, whether it's a couple of days beforehand.
In
because
advance.
I think it's gonna be, so we'll leave open the option of you to be able to submit something else, I would suggest, regarding that issue, if you want to.
We don't mind if the hearing's closed.
Okay. With the understanding that then no other,
Nothing can be submitted once the hearing has been closed,
okay.
okay, from any side. So that's it. Everything that has been presented at this point is all that has been gonna be presented. Nothing else may be received by the board or any of its members. Okay, just make that all clear, so.
Yeah.
Anyone goes to hand you a paper, you are not to receive any papers, okay? All right, so at this point then, I would say I'll make a motion to close the hearing.
I'll second the motion.
All in favor, say aye.
Aye.
Aye. Unanimous to close the hearing. At this point, the hearing is closed. So now I would discuss that we would need to see if we would like to make another date then that we would.
Again, that I would say,
adjourn
that I would recommend being within, today's February 12th, I would say, and again, I'm using conservatively, the March 26, 2020 date would be the 100-day anniversary. We have a bit of a buffer since we have the agreed upon continuance, but I never like getting close to those. So I would say between now and March 12th, if parties are available, that should give enough time for members to look over the evidence and certainly
So, yeah, I'd like to get a consensus from the group here. How long a period do you think we should do? A week, 2 weeks? We have dates that were already submitted by council, which would work for them. If you don't have a copy, I do have a copy in
Okay.
front
Were
of
there
us
other
here.
dates that were closer? I know I'm traveling the end of the month, so I'm careful
Yeah.
that I need
So
to.
again, would a week be a reasonable time? Do you feel that you'd be able to have ample time to look over all materials? And also, if I need to bring questions to council, that's it, we have a week.
Yeah,
Just
So
So we're
the
talking
19th,
the 19th?
February
The
19th
19th.
is the date,
Was that one of-
February 26th, these are the dates that has been submitted to us by their council, so we'd like to try to accommodate you.
The 19th, if that was, I just really want to get.
Does that seem
I think
feasible
like-
for?
Yeah, I think you want the earlier day, when you got council?
219.
319 works for me?
It works for me too.
Okay.
How about our council? Does that work for you? I'm learning,
as of right now, it
I'm
does.
learning.
219?
219.
And
6:30.
I know that the board is aware of this, but just in regards to legal questions, I would remind everybody about the open meeting law.
Yeah, yeah.
So, if there are any questions specific, I would say, if you have them right now that you would like me to research, I think you should do it now. Absent otherwise, Mr. Carey, I'll be speaking to you. Obviously, you should not be speaking to anyone else
Correct.
regarding the matter, but I would appreciate some heads up so that I can begin working on it. Because otherwise, I'm not gonna have a
Yeah,
computer
give you
here, I'm not gonna
ample
have,
time.
I'm not gonna have Lexus, I'm not gonna have Westlaw, I'm not gonna, you know, I'll have the same general information that I was prepared with here today. If there are specific questions that you wish me to research, probably now's a good time as any, to ask prior to leaving here.
Council stated some cases, they cited some mass sites. Is there anything related to other gun clubs that this is,
I
any
don't
mass
know,
site?
I know that there had been some, I believe, either land court or superior court cases that were referenced last year. in my opinion, what this probably comes down to is the second prong of the powers test and everything that's gone from there. What constitutes legally substantial alteration, use, or quantity? So I think that's gonna be the main question. The other two prongs of the powers test, you only need one to hit, where substantial
Okay.
expansion of either use or structure will trigger eliminating the pre-existing non-conforming protections. And I think it's gonna be that second prong that will be of most interest to the board. Whether or not there's a lot on that regarding gun clubs, at least in the appellate levels, my answer is most likely no. I think most of it has been either at the land court or superior court level, which, as you know, isn't necessarily binding unless it happens in your county. But that's my guess of where we're gonna be and where I'd be preparing more for questions from the board next week.
And then powers test is what I was gonna bring up, because obviously that was in effect what we looked at mostly in 2017.
Is that in some file? Or is that
There's
something I can read?
Yeah, there's certainly the decision, or the closing argument from 2017 of Bacon and Wilson. You know, again, as counsel stated, this is a substantially similar issue. Yes, we are dealing with a different club, or a different, again, I don't, area, let's say, of the
Area,
property,
okay.
as opposed to getting into semantics. So that, you know, certainly it's a public document, it's within the files. It's probably informative, and I would just say, my role is to guide you, it's not to make a decision for you. And so, a lot of people don't like that, maybe a little wishy-washy, but these cases often are, they do come down to the specific facts of the matter in question.
Got it. Understood.
So I guess that brings us back to around about the question if we did have any more specifics that we wanted to ask Mr. O'Toole right now, that he would have time to research it. Ron, do you have anything that you?
No.
No. Okay.
No, and I think, for Mr. Bolio, just to probably be able to read the information from 2017.
Yeah.
We'll give you just a background. I think it might be just helpful for you to be informed.
Okay.
So, he's a new member.
So with that being said, that you don't have specific things right now for him to look up, are we still comfortable with the 19th of February as having
Yeah,
the
I'm
next
good.
one?
Yeah.
Yeah, I am.
Okay. So that would be meeting then, not hearing, because the hearing
Correct, the
closed.
hearing is now
Hearing is
closed.
closed, so it's meeting.
So
Yeah, the
it's simply gonna be
CBA meeting.
deliberation with the board, there will be no input, obviously, other than from me if you have questions of me, but otherwise it's more of a forum for the public to watch the ZBA
Make a
deliberate
decision.
the information that's in front of them. Again, not to participate, not to add comments, not to add more documents or more information from either the appellant, the building officer, or anybody else.
Okay.
Okay.
So I make a motion to have our next meeting on February 19th at 6:30 PM at 10B West State Street, contingent upon availability of this building. Notice will go out if it is a different location.
Within 48
So
hours.
Yes, within 48
Whatever
hours,
meeting
ample
law.
time for you to find the correct location. We have not closed our meeting yet, so just to let you know that, so. Does the board have any other thing that they need to discuss at this time?
No,
Yeah,
no,
no.
Is there anything regarding that or anything they need to? Just gonna continue with a point of business for our regular meeting then at this point? That's fine. So at this point, I need to read into record
This is the Granby Zoning Board of Appeals public hearing that was held on February 27th, 2020. And the minutes are as follows.
February 27th or January 27th?
January.
Oh, yeah. January, so we're striking that, writing through, and correcting. Wishful thinking. Just give me a moment. Yes, the hearing has been closed already, right?
Do you take,
We moved and voted, and it was unanimous to
Okay.
close the
We
hearing.
closed-
as long as you got the
we
minutes
closed the
there.
hearing.
We do,
Yeah,
yes.
we
I
closed
was
the
looking
hearing.
over about 3 different things.
Yes, it has all, it was a
Hearing has been
unanimous
closed.
decision to close the hearing, yes. So, strike through and initial the change to, that it was January 27th, 2020, where we had the meeting. The Granby Zoning Board of Appeals, public hearing of, again, January 27th, 2020 was held at the Granby Senior Center, 10B West State Street. ZBA Chair Jeremy Carrier opened the meeting at 6:35 PM by having the members of the Zoning Board of Appeals, ZBA, introduce themselves. Jeremy Carrier, Chair, Ronald Harrop, Rick Bullier, Kathleen Bronner, Vice Chair, Attorney Brian O'Toole, attorney for the town of Granby, also was present. Chair Jeremy Carrier read the public notice of the meeting to consider the petition of the Granby Bow and Gun Club Incorporated seeking to appeal cease and desist order of the Granby Building Inspector concerning violations of Granby zoning bylaws 6.29 special permitting ordinances concerning substantial expansion of a 500-yard range at 85 Chicopee Street, Granby, Mass., known as MAP 15, parcels C3, 4, 5, 6, 7, 9, 10, 11, and 12, as alleged and described in a letter date November 25th, 2019, from the building inspector to the appellant. Chair Jeremy Carrier read the letter from the Granby Bow and Gun Club Incorporated dated January 24th, 2020, requesting a continuance based on the legal representatives due to scheduling conflicts could not be present. A motion was made and unanimously approved to grant a continuance of the hearing and also authorizing Attorney O'Toole to act on behalf of the Granby Zoning Board of Appeals, ZBA, to execute an agreement with the Granby Bow and Gun Club Incorporated to arrange a future meeting date. In the appellant's letter dated January 24th, 2020, alternate dates were offered and the ZBA agreed to February 12th, 2020 at 6:30 PM for the rescheduled hearing. Being no further business, the ZBA meeting concluded at 6:45 PM. Respectfully submitted, February 12th, 2020, Jeremy Carrier, Chair, Granby Zoning Board of Appeals. Make a motion to accept the minutes as read and entered for the date.
Second.
Second. All in favor?
Aye.
All right, passes unanimously. Do we have any other points of business at all for the zoning board?
No.
And make a motion to, oh, no, you go ahead.
I'll make a motion and to close the meeting, the ZBA.
Any second?
Second. Okay, it's
All
going
in
around.
favor? Unanimously. This meeting is hereby closed.